his own interest. But it must depend on the circumstances in which the statement was made. Mr. Trump is not there to explain it. And the court said, well, for me it's difficult to find. I can't go so far as what the state is suggesting the finding was. It was not. And it could not be where the witness is absent and has had no representation and no one cross-examining on behalf of Thales. Down the page 17, just after paragraph 57, the state contends that Thales is not prejudiced to the extent justifying the intervention sought in the application. That is very much the approach in the Botma case. But bear in mind, in the Botma case, the surviving main witnesses were there. It's secondary witnesses. Here the main witnesses are dead. That's the difference. And if I may take you there, Manon, if I may take you to the Botma case. And I think it's quite handy, and we're always careful just to go to the head note. But there is a summary of paragraph 68 in the head note, but it's dealt with paragraph 68. And if I may ask you just to go to the head note, starting with where it deals with, at page 624, my lord. Page 624, the third paragraph. The summary version, it says, held further as to whether the first respondent, that's Mr. Else, would suffer irreparable and insurmountable trial prejudice. That irreparable prejudice had to amount to something more than the disadvantage caused by the loss of evidence that could happen in any trial. Thus, the irretrievable loss of some evidence, even if associated with delay, was not determinative of irreparable trial prejudice. Irreparability in this context had therefore to relate to insurmountable damage caused not to the sources of testimony as such, but to the fairness and integrity of a possible trial. Put another way, to say that the trial has been irreparably prejudiced was to accept that there was no way in which the fairness of the trial could be sustained. That's what we said in the beginning. We accept that in the Botma case, the two main witnesses were still there. It's not our case. If I may, there's just one point that I need to point out. The case is there. My Lord, in fact, all the submissions that I make comes directly from the Botma case, where we tried as well as we could to distinguish between the irretrievable evidence and irreparable damage, insurmountable, what we say we have.
Try to wrap up now, Mr.
It's not up. I take to wrap up very quickly after the tea adjournment. If it's this is the.
No.
I'll be very quick, man.
Yes.
Then page 22 of the heads. The state claims there, in paragraph 65.5, that the facts speak for themselves and support the state's version. That's a bit rich from the state. When you have the witnesses, and your one witness is dead, but you have the other forensic auditor, that's a bit rich to say it supports them. But what's supporting us if the witness is dead? Nothing. Absolutely nothing. My Lord, then on the point that what should be, and we were debating this, what should be the order of the court? Should the court agree with the contentions of Thales? And we had a long discussion, And we initially said in the notice of motion that that you must find that the trial against Thales would be unfair, or that part of the trial, whatever the way the court's going, and that the court then should instruct the state to stop the prosecution. But I don't think the court can do that, because the state is dominant leaders. So I think what should happen is that the courts...
Sir, just a moment.
that
Yes.
the court ruling or the order should be only on the first leg to find that there's irreparable damage to the state's case, that it's unfair to proceed on either all the charges or some of the charges. It is then for the state to decide what to do about that, because the state, as a responsible organ of state, cannot be seen to carry on with a prosecution in the face of an order that's an unfair trial. And the state must then exercise its powers in terms of Section 6. It's not for the court to order them. The state must do the responsible thing. And if the state wants to appeal it and take on, ultimately, and if they're unsuccessful, they will come back to the same point. I don't think that the court has the court can order just an equitable relief. And it's a debate. Is just an equitable relief to order the state to stop the prosecution? Or is it just an equitable relief to say, well, it will be unfair if you proceed against Thales? Then the state must, as the responsible organ of state, decide what to do. And of course, it is then academic that you cannot in the face of such an order proceed. I'm not going into all the case on what's just an equitable. I believe this court has dealt with it many times. It's just simple as that.
And the way I understand it, you say 342A is not the route to go.
No, my Lord, we cannot. And we dealt with that in the heads of argument. It does not provide for jurisdiction to do what we ask you to do. It provides for postponement of the case and cost orders. If I may read it, just find it in my heads where I deal with that. That's simply an
Sir, before you
unreasonable...
proceed, there's a gentleman who's taking a photo of me at the back. Can you please stop doing that? Can you see to it that doesn't happen? I don't know what they're going to do with my photo.
My Lord, that's page 26 of the heads, paragraph 74.
Yeah.
And if I may ask you to turn to page 27, that's the relief in section 342A3. That's refusing a further postponement. That's granting a postponement subject to conditions. It's not there. And ordered as to the payment of wasted costs. And order the matter be referred to the appropriate for administrative investigation and possible disciplinary action against the person responsible for the delay. And 42.5 does not work as well. It says, only in circumstances where the accused has pleaded to the charge and the state is unable to proceed or refuses to proceed with the case, the court may grant an order that the proceedings be continued. That's the typical case where the state comes to a standstill in the state's case and they refuse to close their case. Then the court will say, then I close the case on behalf of the state. That's that power that the court has. But this is not a case where the state is unable to proceed. It can proceed on their basis. So 342 is only inapplicable, my Lord.
Yes.
Thank you, my Lord.
Yes, thank you. Do we take a comfort break before you proceed, Mr. Yes, we'll take a comfort break for 15 minutes.
Like